What I'll do is I'm going to discuss two very important decisions by the highest court in the country and the federal court. And the decisions were given in 2023. One decision was in January, another decision was in April. And the decisions itself, normally court decisions are about 20 pages, 30 pages. But those two court decisions, if you look at this, is about 300 over pages. Alright. But I won't bore you with that 300 pages. So what I'll do is I'll just give a broad overview of what has now been established for planning law purposes. There was a planning law in practice that has now been enunciated by the federal court. You see I've got the 2 or 3 PowerPoints. So you don't need to take any notes because I'm sure the organizers can give you those via PowerPoints after that. One is on the case in Penang itself, the Sunway case. Hills of development. Another one is the Taman Perbadanan in Penang Valley. And then I also got another chart, a flow chart that's to the sequence. What we'll do is, although I have a PowerPoint, but we'll do a kind of a conversation, because otherwise it's too detailed, too technical. I know there are some lawyers here who want to know about the legal details that we can discuss later. The interesting thing is the federal court, there were 2 cases, one from Penang, one from Penang Valley. The Penang case related to hills of development. Sunway, a very big time developer, had got permission to develop on what we call sensitive hill slope. It is 25 degrees gradient and I think 150 feet high. They got permission to build a large number of condominiums and a whole, almost like a township on that hill slope and land adjoining the hill slope. Alright. And they got the planning permission, and the residents who lived below the hill slope challenged the decision. It took many years. Alright, they failed at some stages, but finally the federal court, they succeeded, and the planning permission was quashed. Right, so Sunway, after spending a lot of money, conversion premium, so on and so forth, had that planning permission quashed. So I don't know, I think we see lost some money because they would use some products like it. So that was in Penang. And then the one in KL was KL has got what do you call it, CSR got a Yayasan foundation to help poor people and so on so forth, housing, etc. But what Yayasan did, because they are in charge of KL and so on, there was a 26 almost 30-acre open space park called Taman Perbadanan. Those who are familiar with KL, it's just part of EDI, Taman Perbadanan, apart from KL City Center. And what Yayasan did is, because they got direct links with the government at that time, the Laya was under the minister, Pengurusan, who in a court case, and had to reveal his assets and all that, had to reveal that he had, I think, $1 billion, right, in his savings account, because he's a very prudent person, he saved all his life and that. So the thing is, what Yayasan did is, they said, okay, we cut the land into half, cut the park into half, 13 acres, and these 13 acres now alienate to us, to the Yayasan, right? And we will then enter into a joint venture with this Malton Group, the Pavilion Group, right? Very famous in in care through one of their subsidiaries for them to build a large number of condominiums in that park, and that would be very very lucrative because it will then overlook the park on one side, it overlook PLDC on another side. So there are plans to be like in 7 condominiums, high-rise condominiums, 50 to 70 stories now. And they were on their way, and then the residents in and around the area challenged. Finally, the permission was squashed off. Now, the thing is very interesting. There's one is Penang, one is the these two planning authorities, people with permission for planning, etc., are some of the most sophisticated and developed and most experienced. And despite the fact that they are so experienced in dealing with applications, the process by which they gave the application was challenged. We challenged it, the residents challenged it, and we succeeded. Of course, it took a long time, went to the courts, I think 6, 7, 8, 9 years. But finally we succeeded. So the question is, how come such experienced planning authorities, local authorities, can go so wrong that every aspect of that planning process that we challenged succeeded? And so, just to give you an idea of what now is the law and the practice that is established by these two decisions, right? Now, the first thing is, as far as the courts are concerned, they say planning law is contained in as the Acts of Parliament. We got for Penang, for example, we have the Town and Country Planning Act. For KL, it's special because the KL Planning Act. So that's one. But for the rest of the country, we have the Town and Country Planning Act. And this is a complete and comprehensive code. So the first thing that the court established in both those cases is that this is a comprehensive code and it must be adhered to, it must be followed to the letter and the spirit. That's key, right? And so what it means is that all other laws, private, lawyers raise all kinds of other arguments outside of the act itself, the Town and Country Planning Act, is not relevant really, except in very rare circumstances. Okay, and also certain private rights that you think to acquire are also subject to the Town and Country Planning Act. For example, with regard to Sunway, when they want to build in Sumatra, they said one of the points that they made is, hey, I got a grade A title, and as architects will know, grade A title is almost insulated from any effect. You can do whatever you want, right? So one of their main arguments is, we got grade A title. Grade A title allowed us to build. So what's the problem? How can we challenge that? Otherwise, it doesn't make sense to have a title that is so powerful. But the court said no. The code is the key. The planning law is the key. You can have a title under National Land Code, right, which allows you. You might have, for example, a house in a commercial area, right? And then you say you want to convert it to commercial, but they say no, it's still subject to planning law. So the first thing to remember that this has established is that the Bible, right? The Bible is the act, is a comprehensive code, and it has to be followed to the letter. As I will show how both the adherence, Perbadanan, Penang, and the DKL faltered almost every step of the way in not putting into effect this particular law itself. So the first thing is, for example, you take the Penang case. You see, we had a structure plan. There was a structure plan. The structure plan talked about the fact that you can't build on real slope land, right? But it also talked about the fact that a certain limited development is allowed. So what the authorities did, as the the state planning committee, right? The state planning committee met and devised their own guidelines, right? So they said, oh, okay, now we want to clarify what is allowed because the structure plan does talk about, limited development is allowed. So what is this kind of development? And they drew their own rules and then came up with their own rules and said, oh, so under these rules, therefore, Sunway can apply and that permission and to be granted planning permission to proceed, right? Although the structure plan said that you can't do until development, alright, then state development. So what did the MPPP do wrong in that respect when they said, oh, we are going to follow these guidelines established? But the most fundamental thing that they forgot was that the planning law, as reflected in the Town and Country Planning Act, has two aspects. One aspect deals with development, called developing a development plan, right? We'll come to that in a while, development plan one side. And then the other side is that any landowner who wants to develop the land then must get planning permission. So there's planning control one side. So development one side, development plan one side, planning control one side. So what is development plan? Development plan is where you draw up a plan. The state draws up a plan for the future development over the next 5-10 years, right? With regard to Penang or with regard to KL or whichever area, right? So you have a development plan, and critical in this development plan is what is it? The development plan is actually an arrangement, a very democratic, participatory process between residents and whoever else, the local authorities and the planning authority. So they draw a plan and say, okay, the future of Penang will be like this in this area, this is it, this will be mixed development, this will be a park, this will be etc. etc. Alright. And very critical to that is, because it's part of the democratic process, is public participation. And public participation, the cost must be real public participation, not the kind that we have nowadays. Now they just call you, and then they give you 2 minutes, and then you talk, you say any objection, yes, objection, yes, noted, and then they proceed however they want, howsoever they want. After that, they might take into account a little bit, and you don't even know what they really took into account, and they proceed with the development regardless. So they bypass this whole public participation process, and the court said that you can't do that. The moment you do that, then that permission that you later did based on that, the fact that, oh, the structure plan is like this, so you can do that, is entirely wrong. So that's the most fundamental thing. So what in this case, in the Penang case, what happened was that they just drew up their own guidelines. They say, oh, structure plan says like this, limited development allowed. So now we decide what is limited development, and just came out with minutes and said these minutes are the guidelines and this is the law. What say you can't do that? This is not what how we will put it in Islam. This is not your grandfather's law. You can just drop anything you want one day, group of people meet and decide and say yes, man. Why? Because what you have drawn up has ignored this whole public participation process. That if you want to do anything with regard to the future development, which is going to be allowed in broad brush terms, right, then it has to go through the process. So if you want to do this limited development and start defining, you must go back to the public and present it to the public and say this is how the structure plan is going to be restructured as it were. You must go back to the public, get their feedback. It's a very elaborate process under the law. You have to go through that. You fault on that, whatever follows after that is illegal. So it's the first fundamental thing to remember. Second thing is, even if you go through the process, right, there are objections that are raised. You must deal with the objections, and you must give your reasons why the objections are accepted or rejected. And you must give it at the time when you make the decision. What normally happens is they simply go ahead and do, they give permission, and then after that residents challenge. And then after residents challenge, when residents challenge, they go through a law firm, and they put in an application and complain and all that. Then only maybe 1 year, 2 years later, the authorities, with the help of lawyers, will come up with a reason to justify why the objections were not accepted or rejected. Because you can't do that. Because you are supposed public participation is critical. They have participated. You must give them a feedback. You must give them a feedback at the time when you make the decision, not with the help of lawyers 1 year later when they challenge. Right? For 3 reasons. One is because public participation means you must have an interactive process with the public. Which means when they give objection, you must give answer. You must give it at that particular time. Secondly, is you must also give it at that time because then residents can decide, right, whether to challenge or not challenge. Because maybe a good reasons. For example, you say it's going to introduce a lot of traffic. There's also always a traffic impact assessment when you do a new project. So, if they might have a good reason to say that, we are already providing alternative routes and going to relocate the school or whatever it is. Then the residents, because we have to take up a legal challenge, like in this case, legal challenge was over a period of time, over 7, 8, 9 years, because spend a lot of money, a lot of residents, right? Maybe in luxurious projects affecting luxurious residential sites might be okay. You can afford it, but most people can't afford it. They just complain only, we write letters or social media. So at least when you give a reason at that time, then you and the residents together with lawyers can make an assessment whether or not it's worthwhile filing a case. And the third point is, because the courts themselves say, we also want to know because we have to decide at the end of the day whether or not when you accepted or rejected the objections or you allowed the project to go on with or without conditions, whether it was reasonable for you to have done that at that time. Right, not justification after the event. After the event, everybody is wiser because you start doing more privately. So they said you can't do that. Alright, which it was done in this particular case was the major fault. Then the other thing is, they said, you see, they have a structure plan. So structure plan, they will tell you, okay, and in this area, this can be done, and so on and so forth and all that. And then after that follows a local plan, which you are supposed to do a local plan after that. The local plan gives the details. It deals with the density. Okay, in this area, when we say housing is allowed, okay, how many, what's going to be the density of the population, and what's the ratio also. So that's the details that's spelled out in a local plan. And you're supposed to do the local plan immediately after that. But Penang didn't do a local plan, they just had the structure plan. So the first point that when we argued the case to say you didn't follow the structure plan and so on, and you did it your way. The first point that the other side, right, and get a large levy of lawyers, the top lawyers in the country go all there against us, one representing this group, the other group, and so on. And their reason, they say, no, this structure plan is just a policy. We don't follow the policy. You don't have to follow it slavishly. That's the word that's used. So you can make your changes because local authority, the state planning committee is king. They know what is required for the population, and Perbadanan will implement that, right? So you don't go and don't come and talk to us about structure plan. That's what it is. But we argue against it because structure plan is devised through a very democratic participatory process, and it represents agreement between the residents of Penang and sometimes in that particular area and the local authority. So it's like a contract really, right? So we say it is like an environment contract, for example, in the Taman Ribah case, where the park has been in existence for decades. So when structure plan says that it's an open space, that's already agreed. That's an agreement arrived at after a participatory, democratic process. You cannot simply change it. It's not for you to change it just like that. If you want to change it, you must go back to the process. You want to amend it. Want to change the open space into non-open space. You must go through the whole process again and have the structure plan restructured. Right? So that is the other ground on which the land authority kind of failed because they did not adhere to that principle and were arguing against it. In fact, our law, our planning law, was taken from the British. Early those days was town board enactments and so on. So in 1976, they come up with a town and country planning. So now you have to, in fact, our law, together with the case law that has been developed, is, I would say, the most advanced planning law in practice in the world, in the state of the art now. When you look at the combination of all these factors. Then the state argued, the MPPP argued, they said, actually we got a local plan. We follow the local plan. What's a local plan? Local plan is what they call a plan DASA. They have one plan DASA already. They use the be familiar with the fact that when you go there, they ask you to follow the plan DASA, followed by. And plan DASA goes into detail about the ratio and the density. So they use the local plan and the court at the high court level. That's his I don't know his name, but he made such a bad decision that decided to forget his name. Right? So he said, oh yeah, this is the local plan. They are the lawyers also argued. Prestigious law firm here argued that no, we've got density or ratio, we follow that, that's a local plan. But the court said no, because when you do a local plan, you have to go through a democratic participatory process. This plan DASA is done by one officer from the state planning committee. That's, he drew out this plan. Okay, not his grandfather's plan, So you not do that, you have to go through the process. Local plan also must go through the whole process because it's going to affect people, their habitat, their lifestyle, everything. When you buy a house, right? You buy a house for generations for your children and all that. You don't suddenly, or day after that, suddenly the whole structure, the whole area completely changed in its structure and so on, such that it completely compromises. So unless you are rich and famous and all that, you can maybe move somewhere else, right? But otherwise, you're stuck with all this development which is anti the structure plan and local plan. Right? So they said, no, this plan DASA is illegal. You cannot follow that. Nobody gave you the right to establish this local plan. When we have a local plan devising how to draw a local plan under the Act, under Parliament's Act, you can't simply do your own. Even now also I understand sometimes you go there. Now they know what to do because there's no local plan inside. So they will tell you quietly, from what I understand, you've not implemented the decision at all, Alright. So now they quietly tell you, oh, you may not follow the same goal, but don't tell us that you follow the plan DASA because plan DASA is not illegal. Which is wrong today. Because we can't do that. Alright. Then this was hailstorm land, sensitive hailstorm land. Right. Now there is what do you call it when you go for planning permission, it is done at the what do you call it at the local level, state level in other words, because land belongs to the state and the state decides, makes its decision. But under in 2001 they amended the Act to integrate federal and state. So there's an inroad by federal into state right over land because under the federal constitution, land is the province jurisdiction of the state. And what they did was this, because I think it was triggered by some big landslide, maybe steel towers in the landslide in KL. Because then they established what they call an NPPC, National Physical Planning Council, at the federal level, which comprised of the Prime Minister, Deputy Prime Minister, the Chief Minister, governors of all the states, and of course the agencies and all that. And if it is environmentally sensitive land, alright, environmentally sensitive land, then or environmentally sensitive project, right? Then you must refer to the national NPPC. It's called National Physical Planning for their advice before you make a decision, final decision, before NPPP can make a final decision. And this was clearly a case of that time because it was on hillslope land. And hillslope land under the law is sensitive. Hillslope land of certain 25 degrees in 50 feet is considered environmentally sensitive. So you have to go to NPPC. They didn't do that. The State Planning Committee must refer the matter to NPPC before NPPP can make a decision with regard to any application made for planning permission. They didn't do that. And they argued, you don't have to do it. And what was the argument? The argument was no, because as the State Planning Committee has delegated that function to the Majlis Perbadanan. And we have given certain directives. And under the law, you are allowed to give, State Planning Committee is allowed to give directives. But, as we pointed out, that directive must be consistent with the rest of the provisions of the Act. You cannot give the State Planning Committee, you cannot, CSCI must simply give a directive which violates other provisions of the Act. So they were relying on that and said, and BPP said, we got a directive, since you are challenging our decision, we got a directive, the law allows the directive to be given, we follow the directive, what's your complaint? But you forgot that there's a provision in the On and Country Planning Act which says that any directive, etc., must be consistent with the provisions of this Act. So they got caught out on that, right? Because the State Planning Committee was arrogating to itself, undermining the democratic process. I know you all voted for this government, but you know, that right, we went through a democratic process to elect the government which now wants to act undemocratically in terms of implementation of its policy. Right? So the fact is they argue this point that they don't have to do it and give their reasons why. The court rejected. No such thing. You have to follow. Now MPPP very interesting. The MPPP said, your lawyer said, you know, the planning commission is here, like I told you, there are two aspects. One is development, they do development plans, plan for the future of the Penang and so on. And then there's a local plan. Right? Local plan, one is the development plan and one is the planning control. Planning control is every application must go through the local authority, their planning commission. So MPPP said, why are you talking to us about what is all this NPPC? You never heard of this. Because, you know, application came to us. So we decided the case on the basis of what is our authority. Right? So if you want to challenge what the State Planning Committee did or did not do or gave directive which is wrong or right, then you should have brought them in as parties. But we never brought them in as parties because we were just challenging the planning commission given by the local authority. So they said that what do you call that? So we are wrong because we didn't bring the State Planning Committee. We are out. Majlis Perbadanan is given this application. They decided. The court said no, because when you come to get planning permission from the local authority, it means that the local authority should have adhered to all the processes leading up to that application and the decision to be made. And the local authority had to abide by all the processes. And one critical process is the fact that if it is environmentally sensitive, you must go to the NPPC. If you fail to do that, that was illegal. What you did was illegal. So these are just some of the points that I'm raising, the basis on which the State Planning Committee and the local authority sought to justify the fact that they are right in doing what they did, and have been doing, and should be entitled to do, and should not be questioned, or should not, at least if questioned, should not have any decision made against them. And the court said, it's a 200 word page judgment, 40 page judgment. It is no such thing. So there is much more that was said in much more that went in the decision in application. There's no time to discuss. Yeah, somebody raised their hand, yes.
But isn't that the development plan or the local plan? If it's not that it's still not finalized, it's still in process. And then if you submit your KN, you have to go through the let's say the 20 meters radius or something like that.
Sorry, yeah, okay. Sorry,
Yeah. If the local plan is not presented, if it's still not finalized, can't it still be subjected to changes?
Yes. Okay, so two aspects. One is structure plan, one is local plan. Okay. Okay, so one is structure plan, one is local plan. So once the structure plan is gazetted, then it has to be followed slavishly before the course. Because the other side argues you don't have to follow it. Then you have to follow it. You have to follow it slavishly. You must adhere once it's gazetted. And under the law, when no permission can be given to invalidate the development plan. The development plan is defined as the structure plan, the local plan, and where there is no local plan, then it's the structure plan. So you have to follow the structure plan in any event. But even without a local plan, you can of course give permission, so long as it does not violate the structure plan. Because that's what happened in the KL case, DBKL case. Because that place was marked as open space. And it was marked as open space. And what the authorities, what the minister did, is it is in the land council, which is everywhere, I think. And that is one of the grounds on which the court ruled that the DBKL commission was wrong, was the conflict of interest, because he is the minister in charge of the Wilayah DBKL, DBKL. And he is also the chairman of the Yayasan committee, which then decided to take the land into two and enter into a joint venture with the Pavilion Group, Hotel Group, to develop the land. And in that joint venture, they said, yes, we will use our best endeavors to make sure the permission is given. But here in the minister, who is the oversight for the DBKL, which is the planning commission people who are going to authorize. Here, entering into a joint venture, saying, don't worry, I will make sure that the plan will go through. Which means he has already made a prior decision that DBKL, which is under him, will give the permission. So of course, we raise the point is a clear conflict of interest, then the DBKL does not have an independent mind. They say, no, it's not like that, because when the decision was made, the minister did not sit there. I don't know where he was. But he said, minister was not there, and this was done by the senior officer there. And the senior officer there is very independent, right? And has forgotten that his boss is the minister during the application process. So that was one of the critical grounds on which the court. So this case is also important because it shows judicial control ultimately creates certainty and remove confusion and governance as well. Because they can tell there are some passages in the big saying this is an absurd governance system if you allow this kind of a system. But the best part is, the worst part, is that you are trying to justify on the basis that what they did, all the steps that I talked about which are wrong, all these steps were right. Now this is the incredulous part of governmental authority, where because you see they are supposed to be acting in the public interest. That's the other point that was made by the court. That you as a planning authority are supposed to act in the public interest and not just based on the state planning committee, because state planning committee is run by a political party, right? It's run by the state government is a political party. And the political party has its preferences what to do with developer to I'm not saying anything, but right? And so, and then they give direction to the MPPP, which means they undermine the whole governance system, governance planning law, because MPPP is supposed to be completely independent. That's one of the challenges that we have to make one of these days, because we do a public interest cases, to challenge the lack of independence of MPPP and the local authority, because they always act at the behest of the state government. And they do it because they are appointed by the state government. Of course, there's a structure there and all that, which seems to suggest superficially that there is independent system of appointment. But we know it's not. You go and act outside of your, like now we are seeing at the federal level, people being moved around from NACC, from the police and so on and so forth. You don't act in accordance with your master's voice, you get removed. So where that governance, independent governance structure that has been so carefully crafted through the law by parliament to be adhered to, is not being adhered to. This is the kind of problem we have. So coming back to your point, even without local plan, right? Although you must have a local plan quite immediately after that, even without a local plan, there are challenges that can be made, and there can be challenges made on the basis of a draft local plan. Because usually what happens is, okay, they know they have to do a plan, and then they do a draft local plan. The draft local plan took many years, and they went through all the processes and finalized, but they don't have gazetting, right? Here also, they want to go on plan dasar. Plan dasar gives supreme authority to whoever the state planning committee to decide what they want to decide, right? Which means that there is a complete autocratic system that was prevailing until the decision came in, that was prevailing in the system of planning law and practice that obtained in two of the most advanced local authority dealing with planning law, KL and Penang. Maybe there are others also. All right. So what has happened in these two cases is that the law has been resettled. Actually, it has been brought back with basal rules. They've looked at the fundamental principles governing planning law. That planning law is for the people. Planning law means people must have a direct role. The direct role that they must have must be effectively given, not just town hall meeting of few minutes. And one of the other things they said, for example, with regard to the KL case, you see KL case, what happened at the Taman River Kera there. Alright, and it is accepted by everybody that people come from all parts of the KL to come there and keep it. It's very nice there, right? And the people who challenge were people who live in that area. So one of the things that they always go on to challenge is locus, what they call locus standard. Oh, you have no right. Why you have no right? In case of KL, they say you have no right because under the law, under the regulations, that they give the right to certain people to object. Only those people who objected, a small category of people, but most people don't object. They don't even know they have the right to object, or they bypass the date or whatever it is. They said only that small group of people can object. Only they have the local standard. The court said no such thing. That rule that you must go through that process is illegal, they said, or declared. Why? Because it collects the public participation. Right? If you are adversely affected. So the law then is procedurally, the lawyers will know that is when you are entitled to challenge governmental decisions. If you are adversely affected, so the only thing criteria you're going to show is, are you adversely affected? That's the key. If you are adversely affected and you can show how you're adversely affected, and they say illegality, even one person can raise. Anybody can raise actually. Because it's the illegality. You cannot allow the countenance singing of an illegality. So if any one public spirited person feels something is wrong, they've got the local standard to bring the action. So these two cases also now expanded the right. Last time you must show special interest, although a lot of you are affected, but how are you particularly affected? You cannot show that you are affected over and above all the rest of the residents. Then you have no right to bring the action. Or you must show some direct knowledge. But these two cases have opened this so-called local standard, the right to bring an action. If it's illegal, if it's does not follow procedure, if it's irrational, right? Irrational last time, just to show what is irrational. Last time when per se wanted to go on a rally and all that, they always ask people to wear yellow shirts. So the government came out with a ruling. No yellow shirts allowed in Penang to be worn. Right? So that undermined the whole thing, because it was the trademarks, per se is yellow and so on, super trademark, and it was imminent, the rally was imminent, you see. So they went to court. And said it's irrational, I cannot wear anything, any yellow colored garment cannot be worn in Penang. Full stop. So they say it's irrational, nothing to justify, we can't justify. And that's the argument to the others. Separate point, but that's which is the Attorney General's chambers are supposed to act in the public interest. They are there to protect the public. I don't know why Attorney General's chambers, anytime residents bring up these kind of issues and so on, we should fix them, which means the public interest has to be safeguarded. And they have to go and take action. Actually, they shouldn't need to take action. Actually, the Attorney General's chambers will help them to take the action. Or if they don't, when they take the action, the Attorney General chambers must not object. But we find almost all of the time that the Attorney General chambers, will be fighting them. And we are telling them to this is the public interest and they are fighting us. No, you cannot wear it. See? So there are these two cases, they are legally worded, but you have the time sometime, to have a look through. And they give a lot of insight into that whole governance system relating to planning law and practice. So, I don't think I want to go through the slides. We already have enough UAC products like that. Even I have learned something about that wall cladding and so, I think if there are any questions or matters, we have to have a conversation on this whole issue. But I hope I managed to give you an overview picture of the angle from which planning law and control is regulated now in this country. It's being brought back with Basel rules at the country. Okay.
What's next? Now that the decision has been made, so what changes would that be?
No, well, as far as the authorities are concerned, they have to follow all these steps. They have to follow now. And if they don't follow, then it will be open to challenge to follow over again. But the problem always is this, that when we take on authorities, whether it's the state government or NTPP, they will first they're not bothered, because if they lose, there is no harm to their pocket, the government, right? And secondly, they got deep pocket, but they won't state funds, Whereas you residents, the residents don't have that kind of luxury. Even rich residents, doing a case for Sierra Mas, all very rich residents, who complaining about some stuff and all that. And even they, after a while, they find that, it's a strain to be able to afford, outside of their normal budget for these kind of things. So the authorities have to adhere, but they are not accountable. So supposing someone does something which on the face of it is so wrong, authority, the immigration people are famous for their Director General of Immigration, they have a lot of fight with them. They don't care what they do whatever they want. And then you sue them, then if your client gets damages who pays? You and I pay. Because government pays. Government pays that money from where? From you and me. So that makes sense, really. In fact, we, the citizen, go and sue the government. At the end of the day, we end up paying ourselves. Right? And so That's the other principle that needs to be established, one of the states to establish, which is if it is XAT wrong and the government servant, uh, government servant's act is XAT wrong, then he must be made to pay himself. Because when he hurts him, then next time he will think twice before he decides just to drag mariachin or somebody under Cosma because the government says do that to stop the rally or whatever it is. So this is a problem now. This is a practical problem. So when you say what next, I don't know what next. Yes, sorry.
But isn't our TCPA does spell out for any, let's say, project, you only involve very localized public participation. They say something like you need probably to provide mailings of certain meters away from your site, which is a dead end road, and that distance will be need to cover a lot more. So whatever the public participation is very much localized. We only need to deal with that for any event. That our TCPA style.
Right. Okay, but no, you see, you're talking about the technical aspects of the friend is talking about technical, which means what the setback, what is this, that, and so on. That's very specific. But generally speaking, if you are adversely affected by a project, right, and adverse effect is very wide, the meaning is very wide. You must show up that you're really adversely affected. For example, we are not talking about setback and so on. But one of the things that projects must do when they want to allow for high density is traffic impact assessment. Okay, so what's the traffic impact assessment? Traffic impact assessment is to ensure that the traffic load, because already it can be quite bad in an area, is not so overloaded that it makes your lifestyle, living lifestyle, compromise your living lifestyle. So in other words, the point to answer your question, while there are specific things in relation to the actual grant of planning permission, okay, or what the setback, what you must do, and how many story high and all that. But generally speaking, if a government decision, right, in the context of planning control, you are going to be adversely affected. For example, the Taman Embak era, there is nothing that says that they have the right to access the park, right? But then that park has been there for years. And so the evidence that we led was that they're going to be adversely affected because that become part and parcel of their life. And that is why many of them even bought into that area, right? And why the houses nearest to the area were more expensive than those further away and so on and so forth, right? So sometimes you buy like a condominium, in KL, I live in a condominium, and if it cases, what do you call it, the twin towers. This is the twin towers, they charge you 100,000 more. Alright? And you ask why, I said you didn't build the twin towers, right? But that's how it is. And then day after tomorrow they build another structure right in front of the block. And your view, which happens all the time. Right? So the point, therefore the short one is this, there are specific things that you can object to, and they are violated, right? But on a government decision, it's called judicial review. You review the decision of government authority in anything that they do or do not do. Any decision that they make or fail to make, you can challenge on the basis of illegality, that is illegal, right? That illegal meaning they didn't follow the law, like in this case, or it is procedurally wrong, which is also in this case, they didn't follow the procedure, go to MPTC and so on and so forth, or it's irrational, right? And in any event, it also must be proportionate. Whatever measures the government takes or decision, it must be proportional to the objective for which you are trying to implement the law. All right. So, for example, just to give an example of a proportionate, the immigration authorities if there is a conviction of a foreigner, then the immigration authorities are entitled to revoke your pass and deport you from the country, right? So what is that? It must be proportionate. Then the question of proportionate is supposing a foreigner commits going to pass in the wrong place and is convicted. Can you use that as a basis to cancel his pass and deport him? Maybe technically you cannot, because you follow the law, you need the conviction, you have the right to do this and all that, the right. But then is it proportionate to achieving the objective? What the objective? The objective, of course, is, if you go and commit some serious crime and all that, then the court will say that the immigration authority will say you cannot revoke permission for you to stay this country, right? So if it is not proportionate for a traffic offense, you get convicted and you get sent out, and then you can argue that decision that is made of governmental authority is not proportionate to the objective for which that power was given to the authority. So there is a wider basis than the narrow basis. I think I've been given signal that will prove so now. Oh, great time. Okay, there's one last question. Okay, yes.
The next situation, since the plan does thrown out because it wasn't process. So Penang technically now don't have a legal planning document. Sort of a local plan, we don't have. The structured plan which has shelf life. So as you say now, if somebody goes to the planning department required to this is the plan data that technically is not legal, but what we follow. How then does the process follow that? Because how then does the government planning act is able to be implemented? Somebody goes and submits plan for development based on zero planning legal document. How then does the planning process legally carry out?
Yeah. Okay, that's a good question. The Town and Planning Act provides for that. It says that where there is no local plan, they are not deterred or they are not prevented from dealing with planning applications and information applications. But the overriding point is, aside from the structure plan, not follow the structure plan now. But aside from that, the overriding principle is that if you are adversely affected in any way, you can show why and how you are adversely affected. You can still challenge that. Any information that is given which you feel is adversely affected. To take a simple example, suddenly you bought a piece of land and or you bought a house and so on and so forth, and suddenly they decide, to acquire 2 acres or 3 acres of land next to you, and build a cemetery, for example. I mean, of course, there will be a permission. They will give a permission. They will ask for permission to build the cemetery, to convert the land use to cemetery. Now, if you can show that you will be adversely affected by that decision, you can challenge. But the bonus becomes severe because if there is actual local plan and you violate the density and the ratio, like for example, when we challenge the Taman Bhd case, the density and ratio was 0 because there's no density in terms of residential housing in a park. Because people moving in and out. All right. So there, of course, we got specific provision to hang on to get that, to challenge. But in the absence of that, you can still show you be adversely affected, and why and how you be adversely affected. Right. So without even the local plan, in terms of the Taman Bhd, you can still challenge that you have been deprived of an amenity which has been in existence for 30, 40 years, and there is no rational justification for allowing 7 or 8 high-rise condominiums in 13 acres of land. Right? They try to justify it because that land long ago belonged to rubber estate plantation company, and the government acquired all of that land, right? And what they did was then the workers in that place, they allow them to build, they build for them some terrace houses, student houses, but promise to give them better housing. So the developer very skillfully, the developer then, was supporting a group of them who said, no, this is actually this is being built for our housing needs. They were going to build 5 or 6 70-story high houses for the 25 residents there. That is for their housing needs. And so they use that as a moral ground to show that, this is otherwise it is a promise. But the content of them nothing to do with planning law. That's the other important point. You see? Sometimes they come in and they're nothing to do with planning law. Right? For example, the Sdn Bhd case, developer, you have to subdivide. So to subdivide, you have to put in your application for subdivision and deviation, as you all know. Right? To get title, individual titles. Then nothing to do with Kondominium, for example. And then what the authorities did, I think the Perak land office, what they did was they said, okay, we can give you the permission to subdivide everything, but now the land is going to be leasehold land. So they converted freehold land into leasehold land upon the application by the for subdivision and deviation. So they took the matter to court and finally went to the highest court. Because they found there nothing to do with planning. Your business is planning. They have come here to ask you for planning permission. You use planning principles and any planning law that exists, or if it does not exist, answer the question, the general planning principles. And this conversion from freehold to leasehold is outside your legal jurisdiction, and they struck down that, so you can't do that. But that always happens. I think as architects, you are very familiar. I think one of the cases in Penang, where the developer wants permission and puts in an application for subdivision, and they ask you to build a road somewhere. Alright, they have to build a road somewhere. And then you don't want to build, and then they say, no, okay, so and so will build, but then we're going to get all expenses of building of the road from you, all your subsidies at any other time and open-ended and all. That's the challenge. That's the case. They apply anything, anyhow. But what these court decisions have shown very clearly, right, inherited now, it also has structured the governance system, a character of the governance system. There is a particular governance system based on a comprehensive code that you have to follow. And the final point on this is sometimes it is not, as the Malay says, not explicit, not tersirat, the spirit of the law is also applicable. So you can also apply this principle that, okay, maybe not specifically provided for, but when you look at the spirit of the law, when you look at the structure plan, when you look at so on and so forth, then the basis for you to question the permission given. I think.
What about the 20% leasehold extended?
Sorry?
In the recent case,
Yeah.
the government will apply the rules whereby we will extend the lease in KL and what happened. So you need to
Give 20%.
20%, yeah.
Yeah.
What's the case?
Yeah, I can't give you the answer because there's a chance I might get the case and reduce my fees right here. Okay, I think you.
10 minutes.
Okay,
We will have 10 minutes tea break. Thank you.
Yeah, the heritage only. Heritage means are complete petroleum. Yes.
Hello. Okay, let's define to zero. Move on here to solve.
Okay, thank you. I think one in the course of the break, one of the questions that was in the discussion, one of the issues that emerged is that what sometimes happens. Maybe somebody can close the door. Alright, one of the issues that happens is this, you put in your application for planning permission, then the SPC makes a decision. I don't know whether formally or informally, and SPC will approve it. And then what happens is when it goes to the planning authority, which is the MPPP, they say, it's been approved already by our bosses and all that, so what is that? So they more or less follow it. In fact, that was one of the arguments that was used in the Sumayara case. Because they say, under the law, by way of an amendment, the planning authority can take into account in the grant or refusal of planning permission, A, the development plan, and B, any directive given by the state planning committee. There's a provision. So they rely on that, and they said that as far as this development was concerned, to allow for hill slope development of these condominiums, they said it was allowed because there was a directive given by the state planning committee. And the state planning committee also came up with the affidavit to say, yes, we gave this directive. So they rely on that provision in section 32(2)AA to say, yes, that we follow the directive, so we can't complain. But our counter to that, which found favor with the court decision, is that it has to be any planning permission. First, it relates to proper planning. That relates to one of the questions that was raised earlier, where you don't have a local plan, but you still have to adhere to proper planning principle. And that is written in the law itself, in the town traffic planning. But aside from that, there is a particular provision which says that any section 4, which says that any decision made must be consistent, but be consistent with the provisions of the act. So you have to follow the whole scheme of the act, and the directive must be in the context of that scheme. In the context of the scheme, any directive is given, which does not does not violate the provisions of the act. Then only the directive is valid. And the court saw that. The court said the directive cannot override the provisions of the act. So what if indeed the state planning committee is doing that now by approving maybe in principle, so-called in principle, and then just sending it to the local authority to make a decision. First is that the power to make a decision cannot be delegated, cannot, in other words, the decision cannot be made by the local, by the SPC or the state government, and then delegated to the MPPP to carry it out or to give effect to it. You cannot do it because the decision maker is MPPP. So once the decision maker is MPPP, only they have the jurisdiction to make a decision. Anyone who says that they make a decision and delegate it to someone to carry out the decision is violating the law, and that is made very clear. By this case, as well as by a general principle, which is that if you are given an authority, then or if you don't have the authority, you cannot then using your broad powers of delegation, because state government has powers to delegate up to carry out certain things. You cannot use the broad powers of delegation to ask others to follow your decision. So that's wrong. So what they are doing now is wrong, and this can be challenged. But then that whole process, I will go through this whole tedious process of looking up for, going through the court process. It is very long and tedious and expensive, right? We do most of these cases, planning law cases, for residents, usually we do it on a very reduced fee or pro bono basis, free of charge, because it's the public interest, it's a lot of public interest. But otherwise, it's a very expensive affair, because you go through the various stages. You got to start up with the High Court, then the Court of Appeal, and the Federal Court. 3 years. In fact, I think it was Taman Bhd case, the court awarded against the developer and BDK a cost of 300,000, which is phenomenal. It's very unusual. Usually 30 or 40 or 50,000, and they give a bit more, which is quite unusual. But here, I think they wanted to express that's my own personal view, I wanted to express their strong views on the impropriety of what has happened, what has taken place. You see, what happens is, for example, like in the case of the Taman Bhd case, they had got into a joint venture with Yayasan, which is an arm of the and then they paid out a lot of money. The Mountain Group paid out a lot of money just for the conversion of something that was 60 million. And then, of course, after that, they had to prepare for bridging finance and so on and so forth. So that they carry out the activity, their consultant, and so on. So obviously, they have incurred, possibly 3 million, right? 60 million is a given. And now they were claiming what we heard. Now they are claiming from the government 200 million. They are saying, we give us planning permission, we prepare for it. And now, it costs a lot of money. But the fact of the matter, in fact, we are blaming the government informally at the moment, not to pay, because you entered into a joint venture agreement. And it's nobody's fault. You entered a joint venture agreement, and the joint venture agreement has turned out to be wrong. It's not the fault of Yayasan or DDK. It's also your fault because you are the one also involved in the process. So maybe the 60 million for conversion to the premium date they can recover, and usually I think plan office is really quite fair thing to give back that money. But to ask over and above that all your other costs which they are trying to is ridiculous. And if the government does pay out, then you will challenge it. You'll challenge the government for having paid out wrongly. Right? But the problem then is, like I told you at the end of the day, we win the case. The persons who committed the error are not penalized. So it's asked to be penalized. Okay, so anything else? I think after the coffee, everything is settled already.
In Penang, because of the issue, in Penang, there was the issue because of scarcity of land and all this. There were problems with the one of the there was a collapse resulting from deaths and all. So there's a request from an EIA to a DEIA. So the state, if you were to pass this thing and the state assembly. Now, can you please, because you've done this sort of thing, can you please
What is DEI?
detailed environmental impact assessment as opposed to a EIA? Because the DEIA will take into account many of the facts as well as public interest.
Yeah, you see, I have personally have problems with EIA. I mean, about DEIA. Right? The reason is this, very simple. Because the EIA is given by the project proponent. The project proponent engages a consultant, right? And he gives a report. Now, he's not going to give a report which says that, this development is bad and that you cannot proceed. So, even if there are some qualifiers, they qualify it very carefully, they cushion it very carefully, and say it may be said that, however, there are ways to provide for it and so on and so forth. So the EIA process is actually a sham for two reasons. One is, of course, the consulting thing, and the second one is the fact that sometimes some people, I think 50 acres and then isn't it, you need EIA for some, and some more than 50 acres, so they do it in phases. I do 40 acres first, and then tomorrow I do another 30 acres. So it's a sham. It shows the lack of commitment, and it has to be challenged. In fact, some of us are involved in revamping the Environmental Quality Act to make it circular environmental policy. That means right from beginning, say you're a manufacturer, right from beginning, the word waste should not feature anywhere. There should be no waste, zero waste, which means right from beginning, when you start manufacturing whatever it is, or containers, right up to the end, it has to be zero. But one of the important things that is the safeguard is exactly this EIA. But EIA has to be provided, what we have provided for, the government is not taken up the act yet, is that you must have a panel, established panel of people with integrity or consultants, and the project proponent chooses from amongst those listed panel, right? And the payment is made through the government, right? Payment for the EIA consultant. So the idea is to try to establish some integrity to the system, because otherwise it is just it just washed through. I've never known of a EIA that rejects the project proponent's project, and it's followed by the government to reject it on that basis. I know of none, maybe US architects know of some, right? The most pronounced is the Akun Dam case last time. The EIA that was established. I think the case also for the Orang Asli and so on. And there it's ridiculous. The EIA, it's very easy for our experts to look at the EIA and show that the EIA is bumped up, I think I just trying to gloss over some of the problems with regard to habitat and so on and so forth. But it got through, right? But at that time, the ministry, say, oh, the EIA is there, you not know what's your complaint. And you say, no, because this, they already dealt with by the EIA, right? And come on with the decision of that kind. So the fact is, if you keep in mind the fundamental principles that are applicable, alright, of course, they can be sidelined by other considerations that we know of. But the fact is that the only way is by a sustained challenge, but it's very exhausting for residents. Because there's in here, I don't know about Penang. And even when, for example, if the density is a certain, it's supposed to be a certain amount, I noticed some of the buildings here, they suddenly, the rezoning, or sometimes the density is increased, alright? I used to know that during Cheng Yang house, the one in the corner there, Northern Road, I saw the old house and the old man the lawyer also, so that, but the house is maintained, but behind it is something. New structure, that definitely must violate the,
If we were to follow the principle of the town and country planning act, it's a deviation of this UNESCO area of Georgetown is illegal. The whole Georgetown is a UNESCO area, right? So I do not think they follow the principle of this town and country planning. The process, everything, to get it.
so I don't think it violates the town and country planning, but it is to declare the whole area within a certain character. And I think ascribing a particular character to the area, I don't think it violates any structure plan or a local plan. It will violate if they
convert something to something else that violates the structure plan, for example. But otherwise, they're just saying that this whole area is, to be preserved as a site that is of a heritage level, is it? Yeah. 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 Well, you see, there are two things. In planning control, there are decision making, there are two things. One is whether they violate the law itself directly. Okay, that's one. Catch. All right. And what policy to adhere to is a separate issue. That one courts cannot go into because courts are not in a position to decide on what's a good policy for housing and for this. So courts judicial control is only through the what do you call it, the provisions of the act itself. So what policy to adopt and how to implement it and so on and so forth and what weight to attach is a separate matter. They want to increase housing in one particular area because they want affordable housing. Okay, then they change. You are allowed, there are certain exceptions to the Town and Country Planning Act, so you can have, but you must justify it, right? Like that case of the cemetery I was talking about. They want to convert the cemetery. People objected. They say, how can you have a cemetery next to me? Some more, it's we are non-Muslims and this is a Muslim cemetery. All this kind of identity issues and all that. But the court evaluated and said no, that this is needed, and the reason why there is a need for that, okay, that's a policy decision. Yeah, but we have to look at it carefully, because like I told you, that you can't just simply put forward your own plan and say, like the Plan Dasa was in operation. They said the Plan Dasa was in operation for don't know how many decades.
They created a special area plan, and then they approved the scheme. So whether the state planning committee by creating a special area plan for certain area, whether that follow the legal procedure according to the act or not. Like for example, right now, I believe even in whole Malaysia, we have a lot of structure plan already gazetted, but the structure plan.
Oh, sure.
Yeah, but the local plan, a lot has been prepared, but it's not gazetted. It's just a draft, right? And what happened right now? A lot of states actually they are using the state planning committee, to do rezoning, increase plot ratio, to change the use of the land, whatever. Whether is that legal or illegal, without gazetting the local plan.
Yeah, first is it's not mandatory, although the court did say that shortly after you do your structure plan, you must do your local plan. And if you don't do it, then they look with suspicion at your conduct after that in approving without having the local plan. Okay. And that aside, the fact is that if you see you got a structure plan, if this SAP, is it? SAP, yeah? If that conflicts with the structure plan, it can't conflict. They can do it, but they have to amend it. What this case established is if you need to amend it, then you have to go through the process again. That's what's established. In fact, I got one case coming up next week in KL, the KL CP, they call it KL Comprehensive Plan, which is the local plan in KL. And they're making a lot of changes to the previous plan. But they are saying we are making plans because we need to make the plan, because otherwise KL, cannot be a beautiful city and all that. You can't do that, You have to go through the process because the local authority is just a mediator between the people and whoever else is going to, interfere with you, right? It's just a mediator. It is not it's not a Nazi Germany kind of position, which is what they do, you see, which is what our government, our state governments do. And then if you challenge them too much, they say, okay, fight me in the election, this is election issue. And then when it comes to election, you don't want to vote against them because they say, yeah, got green wave already. Then you panic already, Then you put them back in power and you challenge them, they say, yeah, okay, vote me out now. So it is a vicious cycle that needs to be broken. And some of these cases do break that. But the fact is that the citizenry must be alert and take them to task at each time. And if they keep repeating it, then we have to ask for any damages to be paid for by the people who are making the decision, right? Instead of the public authority, instead of making the public authority pay. So in short, if you got a structure plan which has been gazetted, and anything that disturbs that structure plan in whichever way possible, then it's illegal. Secondly, even if there is no local plan, even if there's no structure plan, can the authorities approve? Yes, of course, because people want to develop their land, want to do changes and so on. Of course, they can do it, but they must follow proper planning principles. Thirdly, there is a process called judicial review, which is the courts are the final arbiters that you can then bring an action to say that the decision that was made, whatever the decision is, doesn't matter, whatever the decision is, it adversely affects me in a way which compromises whatever it is, compromises the provision of the act, the spirit of the act, or my living lifestyle and so on. For example, like a park. Park is, nobody guarantees you a park when you go and buy a house, you see. But you say for the last 30 years, or I bought the house on the basis of that. So that is again, although it's not directly in violation of any specific provision, but of the law, but you can still challenge, even if there's no structure plan which says it's must be an open space. Of course, if structure plan says open space, your position is strengthened and you fight it on that basis, which is what we did, because it says zero density, zero ratio, right? But even if it is not, it is open to the citizenry to do that. The only problem or downside sometimes is, our residents itself, they see a big development coming up next door, they say, wow, that means my property will go up by another 30%. So even I know some of this residents association, right? There's there's a conflict within the residents association. Some want to do, some don't want to do, right? Because they feel that development is good, right? It will enhance the whole area or the property prices and so on. Yes. Sorry, come again, your question what? Oh, yes. Well, yeah, you see what happened to that, the history of the case was that there was objection to the planning when they wanted to decide before the decision making. The residents objected, but then the residents' objections were overruled, and Sunway was given the planning permission. Then after that, the citizens, the residents there have the right to object. It's a right given to object. So to appeal. You appeal to the appeal board. So they appeal to the appeal board and the residents won. But after that, there is, so that a decision was made by the appeal board. So that, like I told you, any decision that is made by a government or governmental authority and so on, official body can be challenge in the court through judicial review. So this is what they did. They went and brought an action for judicial review. And the judicial review, Sunway succeeded. And then we came in, then the residents appealed to the Court of Appeal. That's why we came in. Residents appealed to the Court of Appeal. We lost. The court took 2.5 years to make a decision. All right, just to affirm the High Court. And then we took it up on federal court now. But that's how the process was. But the disgraceful part, if I could say that, right, is that the state authority, all the while, instead of siding with the residents, as they promised to do, right, all the while sided with the developer. But that's the shocking part, right? Because I was in consultation with the state government authority and whoever is in charge, and we were discussing. So before the election that time, they promised, oh, we will support the residents and this, and how can the MPPP make a decision on that? But after the election, then suddenly when we appear in court, they are engaged lawyers to fight us and ask for costs when we lost. Then later when we told them, what the hell, you practice deceit on the residents. Then they said, no, you bring the residents here, we talk to them, and then brought the residents, they said, no, they should must. Then the residents were angry and want to, say certain, not 4-letter words, but, 5-6-letter words, right, to the people, the highest authority in the state. They said, no, forget about the past. This is a miscommunication, from, sometimes when we say certain things to the authority, they don't know how to implement that, they talk like that. But we must be forward-looking, right? So forward-looking, when we went on appeal, they engage even more powerful lawyers, right? So end of the day, they have to pay, I think, for that case, it was about 100,000. But they don't, it's not out of their own pocket, they don't care, This is the problem now that we have with the government, the so-called democratic setup. Yeah, sorry.
Takeaways from Rimba Kiara is that joint management bodies don't have the locus to participate in any judicial review. That is correct. Yes, Dato? Yeah. Now, on that basis, Dato, just to follow on to one of the questions asked previously, one of the requirements of planning permission is that all neighboring landowners must be given notice under Section 21, subsection 6. Neighboring landowners, either you're adjacent or 200 meters down a cul-de-sac. Now, the common practice that we understand in Penang is that if there is a development project, the notices regarding the objection hearings are normally sent to the joint management body, the management office, instead of all the individual residents. Now, based on the decision Rimba Kiara, where they say the JMB doesn't have locus, of course, there is a judicial review case. Would this mean that service of the notice on the joint management body or the management office would be insufficient notice because you're not serving it on the individual neighboring landowners? So, my understanding is there are Court of Appeal decisions that say that if you don't inform all neighboring landowners, planning permission is null and void later. Would this apply there, Dato?
Good question. First is joint management body, and after becomes the management corporation, all right? Do they have the local standard to challenge? The court in Taman Rimba Kiara said no, but the reason is very specific. The reason is because if you look at the Strata Management Act, all right, the joint management body got certain powers, specific powers, what they can do and what they can do. So the court, when they looked at it and said, this is not one of the things that they can do. And so therefore we are setting it aside. That we are saying that joint management bodies by themselves cannot challenge because they are a statutory, they got statutory powers as determined by the statute. So go by the statute. So insofar as there's no specific power for them to do that, although we argued under some general principles and all that, but they said no. On the second part is actually the joint management body are the owners lah. Are the owners constituting the represented by the JMB. So it's not so easy to say that if a notice is served on JMB, it's ineffective because then they'll argue saying, yeah, but you can't be serving on 200 owners and many of them rent out the properties anyway, right? So we have to find the real owner. It might be in Australia or UK or something like that. So it's not so easy to use that as a ground, although can try, not so effective a ground. But over and above that, as I said earlier, the right is given to anybody to challenge a governmental decision. So it's not just the neighbors. You see, they try to argue that it's only that group of people under the rules, not under the main act, but under the rules, who are given the right to the whole objection process. And therefore, anybody else challenging, because we brought in the residents association and some residents and all that. Anybody else has no local standard, the court ruled that out. They said no, that these people do have the right. It's not just those who are confined to the objection. And you cannot confine it to those objections, those people limiting them to object. And they ruled that rules also they threw it out and said the rules insofar as they limit it is illegal. Threw that out also. Like
one-stop center, which is chief minister in Penang, we call it chief minister incorporated. One-stop center is a center with is this good policy?
On what? On no, restructure. No, you can't restructure unless you go through the process. Is it? No, but what is the objection to that? That's the point. Because one-stop center is just to, what do you call it? Coordinate. So that they don't have to go here, and all that, and come back, go. No, you see, that is their own the so-called democratic process that they have established. But in any event, you see, the point is whether the power is, in our system, right? It's always, the chief minister or the prime minister who makes decisions, everybody else follows. Because they have such vast powers. Prime minister can chuck any minister out, under the federal constitution. So everybody wants to fall in line lah. But it's for the party and for those people for the government to decide to how to make the process. Yeah, sorry. Oh, sorry, somebody else, you first and then you.
Doctor, I asked another one, which is the recent case. The Deuter Enclave, one of the longest civil case. The High Court recently asked the state government to return back the land, whereby it has already developed, with a lot of things in there, back to the original company. You have, what you call, the background of it.
I don't know the details, so it's difficult to comment. Why? All I know is what I read in the social media where the High Court ordered, and then Anwar said he want to review the law, to change the law, and he's going to bring it to the Parliament in October. But he's going to bring it. But I don't know what the real basis on which they asked for the return of the land now. Unless someone knows, and then we can comment. Yeah, sorry. Yeah.
Let's say if any individual the authority has notified the JMC through registered letter or any, and if the JMC has no objection to it, okay, is it possible for any of the residents to send in an objection?
Yes, answer is yes, because JMC is just representing the landowners.
even though they have no objection, but.
No, the JMC is representing the landowners in respect of the duties that are spelled out in the Strata Management Act. So that's their limit of their duty. They cannot compromise the rights of others. So if there is a person whose rights are affected and feels affected, the JMB cannot use the fact that, oh, JMB agreed.
The JMB carry out a proper procedure, notify all the residents, come for a meeting, and then raise their objection, whatever, and then make a decision after that. Would that actually represent all the residents in that case? Even some did not attend?
Well, I mean, generally speaking, that's how, what do you call it? That's how societies and all this operate lah. That, you know, you have a AGM or EGM, then you bind the others. But in this case, that they cannot bind the owners if they feel that they are adversely affected. So the answer is they can't bind them. So it is for matters within the province of the JMB, you know, and running the place and this, and whether the gardener is going to be paid extra and whether they are going to do a fumigation and all, or within their powers. But outside of their powers, they cannot compromise other people and say, oh, you cannot go for Order 53 of the rules where you are adversely affected. They can't compromise you on that. Okay. So that's it. Thank you very much. I must say, very patient Saturday audience, which I've not experienced in my life yet. This is a new experience for me. Thank you very much.